This module is entitled Supportive Measures in Response to Reports of Sexual and Interpersonal Violence. I'm Adam Wilkoff, the Assistant Director of the Student Conduct Institute. Both federal law and some state laws, such as New York State's Education Law 129B, require colleges and universities to provide supportive measures to students pending the outcome of a disciplinary process arising from sexual and interpersonal violence. This training will cover those obligations under the Violence Against Women Act, the Clery Act, Title IX, and New York law. We will highlight both legal requirements and best practices, and we will look at some areas where courts have divided on institutional liability in providing supportive measures. We will specifically highlight how the Title IX final rule, issued by the U.S. Department of Education on May 19, 2020, shapes the rules governing supportive measures. Colleges and universities that have been following previous federal laws, regulations, and guidance on supportive measures should not have to make significant changes to their policies and practice to meet the final rule, although they may need to consider whether they have adequate systems in place for receiving reports, providing requested support, and documenting their response. Our first learning objective for this course is to review your campus's duty to offer supportive measures to complainants. Our second goal is to understand the need to provide equality and accommodations for all parties. Any measure offered to a reporting individual during the grievance process must also be offered to the respondent. Third, we will consider the range of supportive measures available in a conduct proceeding and when they are most appropriate. In the first part of this module, we will examine a college or university's duty to offer supportive measures to the parties in a proceeding arising from sexual and interpersonal violence. The key takeaway is that institutions have a duty to offer supportive measures, but are not liable under Title IX when parties decline to pursue them. Courts say that an institution only needs to put the ball in the student's court. It's up to the student to decide what to do. Ordinarily, an institution only becomes liable under Title IX if the student asks for help and the institution does nothing or acts clearly unreasonably in refusing the accommodation. In the middle portion of the module, we will discuss the duty to offer equal accommodations to the parties. Both Title IX and the Clery Act, as amended by the Violence Against Women Act, require equal access to supportive measures for all parties. New York law also demands equality in accommodations. We'll go over some of the challenging situations this presents, such as housing moves in advance of a disciplinary proceeding. Finally, we will discuss specific supportive measures often used by campuses, including housing changes, academic modifications, and accommodations for students' physical and mental health. The Violence Against Women Act, or VAWA, was reauthorized in 2013 with certain amendments considering campus response to sexual violence. The Department of Education then issued regulations implementing the law. Among these regulations was a requirement that colleges and universities provide written notification to students and employees about resources available to victims of sexual violence. This would include existing counseling, health, mental health, victim advocacy, legal assistance, visa and immigration assistance, student financial aid, and other services available for victims, both within the institution and in the community. Those regulations also require colleges and universities to provide written notification to victims about how to obtain accommodations from their institution following an alleged sex offense. This written notification includes options and how to request changes to, quote, academic, living, transportation, and working situations or protective measures, unquote. After the institution provides this written notification, it's up to the victim to request them. The institution must make accommodations if the victim requests them and if they are, quote, reasonably available, unquote. In enacting regulations to the 2013 VAWA reauthorization, the Department of Education was careful to distinguish requests for protective measures from other parts of the disciplinary process. While the parties are ordinarily notified at the same time of all meetings and hearings in the process, the institution does not have to disclose meetings between a student and institutional officials about obtaining interim protective measures. Those are not considered part of the proceeding, and there is no requirement to disclose those communications to the respondent. Once a protective measure is put in place, the respondent has the right to be notified of the protective measure and seek review of it through some type of process. Along with the requirements of VAWA and Clery, Title IX itself puts an obligation on the institution to remedy discrimination by offering reasonable accommodations to the parties. While a student does not have the right to demand a perfect or preferred remedy, the institution cannot act in deliberate indifference to the student's needs. Put another way, the response cannot be clearly unreasonable. This is the standard announced in the U.S. Supreme Court's 1999 decision in Davis v. Monroe County. In evaluating whether an institution's response is clearly unreasonable, courts distinguish between institutions that ignore requests for accommodations and those that offer options but do not take affirmative steps to implement them. As a federal district court in Connecticut wrote in the 2003 decision, Kelly v. Yale University, an institution may be liable under Title IX if a reporting individual requests measures, but the institution does nothing. By contrast, there is likely no liability for failing to offer accommodations if the institution offers interim measures, but the reporting individual declines to select them. As one federal court in California put it in the 2016 decision, Moore v. Regents of the University of California, it's not plainly unreasonable for an institution to, quote, leave the ball, unquote, in the reporting individual's court. The institution's duty is to offer counseling and instruct the reporting individual on the process for obtaining interim accommodations. According to the final rule, supportive measures are non-disciplinary, non-punitive, individualized services offered as appropriate, as reasonably available, and without fee or charge to the complainant or the respondent before or after the filing of a formal complaint, or where no formal complaint has been filed. Such measures are designed to restore or preserve equal access to the recipient's education program or activity, without unreasonably burdening the other party, including measures designed to protect the safety of all parties or the recipient's educational environment or to deter sexual harassment. The final rules draw a clear line between disciplinary sanctions and supportive measures. A remedy cannot be both. For example, if a student's loss of athletic eligibility is a listed sanction, then it cannot also be listed as an available supportive measure. Likewise, the final rules forbid schools from issuing interim suspensions of students pending the hearing because suspensions are disciplinary sanctions. Instead, a school can apply the emergency removal process, which is described in a different SCI module. As was true before the final rules, the Title IX coordinator is responsible for the effective implementation of supportive measures. Now, the final rule creates specific record-keeping of the measures offered and provided. This record-keeping requirement demonstrates compliance with the institution's responsibility under the final rule for providing a response that was not deliberately indifferent, meaning not clearly unreasonable under the circumstances. Again, this standard largely comports with the standard applied by courts reviewing Title IX cases brought by complainants before the final rule. Now, that standard will apply to OCR review of campus response to sexual harassment. Keep in mind that providing a not clearly unreasonable response means that OCR does not expect a perfect response. When developing appropriate supportive measures, the Title IX coordinator must engage in a meaningful dialogue with the party. The department indicates in the preamble that a school's obligation to provide supportive measures does not imply that the school must prevent or resolve the trauma a complainant experiences. The department writes that the measures must be designed to provide equal access to educational opportunities for the complainant, but need not guarantee this outcome. In providing those supportive measures, the Title IX coordinator must maintain their confidentiality, to the extent that maintaining such confidentiality would not impair the ability of the recipient to provide the supportive measures. In other words, if the supportive measure imposes a reasonable burden on the other party, such as requiring them to adjust their class schedule, then that measure can be disclosed to the affected party. The final rule itself describes several supportive measures that may be offered to a party. They include counseling, extensions of deadlines or other course-related adjustments, modifications of work or class schedules, campus escort services, mutual restrictions on contact between the parties, changes in work or housing locations, leaves of absence, increased security and monitoring of certain areas of campus, and other similar measures. The final rule generally doesn't prohibit other kinds of supportive measures as long as they are available equally to the parties. Equality in providing supportive measures. Institutions must engage all parties to the student conduct process in an even-handed fashion. They must provide equal access to counseling services and other resources from the beginning of the process. For example, in Doe v. University of Denver from 2018, a federal court in Colorado held that because a male respondent received the same list of resources for navigating the Title IX complaint process as the female reporting individual, there was no evidence of gender bias in providing counseling services. And that was true even if those services were victim-centered. The record showed that the university's Center for Advocacy and Prevention Empowerment did not exclusively serve female students, and its Health and Counseling Center and the university chaplain were also available to students accused of sexual misconduct. Similarly, in UV Vassar College from 2015, a federal district court in New York held that a college didn't show bias in providing counseling services when a male respondent received written materials along with the conduct charges indicating that he could access resources in connection with the conduct proceeding. The fact that the reporting individual received help from a counselor did not show anti-male bias, as those services were available to respondents as well, and the respondent admitted he had never requested help. You'd have a different outcome, of course, if a college's counselor openly disparaged a respondent seeking help. So, in Mancini v. Rollins College, a 2017 federal case from Florida, a court decided that a college would have violated a respondent's Title IX rights if, as alleged, its Title IX coordinator cursed at the respondent instead of providing him with impartial guidance and resources, as required under the Code of Conduct. Institutions also have a Title IX responsibility to provide equal access to disability accommodations to the reporting individual and respondent. This topic is covered in more detail in another SCI module, but the basic rule is that the student's job is to inform the Title IX coordinator or conduct office of the need for a disability accommodation. There's no constructive notice to those university officials, even if that student has received academic accommodations in the past from other university departments. For example, in Doe v. Quinnipiac University, a university accommodated a respondent diagnosed with ADHD by providing him extra time to review a 250-page investigative report and to submit a written response. The university then provided 3 accommodations at a 7-hour hearing. First, it arranged for all questions regarding a specific event and date to be kept together. Second, it allowed him several minutes to process questions and regroup, with assistance if necessary, so that he could recall the context of the question at hand. Third, he was given breaks every 15 to 20 minutes to ease his cognitive load from the questioning, during which time he could clear his head and confer with his advisor. The question of equality in interim measures is tested when one party requests a measure that directly impacts the ability of the other party to access campus resources. Take one typical example. You receive a complaint of sexual assault in a residence hall. The students share the same residence hall floor, and the reporting individual asks that the respondent be moved. The respondent says this move is illegal and prejudges their guilt. Can the respondent be moved? The answer is generally yes. The Title IX final rules do not require that supportive measures impose no burden on either party. According to the preamble, any burdens imposed on the other party must be reasonable and cannot unreasonably interfere in the affected party's education. The department declined to outline a list of what measures might be considered to unreasonably interfere with the other party's education. In publishing those rules, the department did not comment on whether it is appropriate to put a slight burden on the respondent in favor of the complainant in Title IX cases. Instead, the department provides an example in the preamble of how to balance a complainant's need to avoid seeing the respondent with the respondent's interests. It writes in the preamble that it would not put an unreasonable burden on the complainant to move the complainant if that party does not want to see the respondent. This does not mean that the school should always move the complainant in these circumstances, only that the department would not ordinarily view that decision as being unreasonable and therefore violative of the complainant's Title IX rights. Along with finding support in the regulations, case law would also permit a campus to move a party from their housing in the wake of a sexual misconduct investigation.
Case law makes clear that victim-centered solutions do not violate Title IX, but these accommodations cannot show gender bias. In Title IX lawsuits, accused persons often argue that an institution displayed gender bias, which is not allowed under the law, when it provided interim accommodations to the reporting individual, but the law says otherwise. As an Illinois federal court wrote in 2017, a university may extend interim measures to the reporting individual and not give those same benefits to the accused person because it has a, quote, legitimate and reasonable bias in favor of alleged victims of sexual assault.
For the last portion of this module, we'll take a closer look at the types of supportive measures available to parties in a disciplinary proceeding arising from sexual and interpersonal violence.
First, there's housing. If the reporting individual and respondent are roommates or live in close proximity, the parties may request to be moved to new housing. This measure is not a sanction against the party who is moved, but an administrative action pending the outcome of the disciplinary process. Failing to take this interim measure may constitute an unreasonable response in violation of Title IX. In a 2008 case from Arizona, for example, a reporting individual was allowed to proceed to trial on a deliberate indifference claim against a university, where that institution allowed the respondent to continue living in the same residence hall as the reporting individual for 3 weeks after the filing of the complaint of sexual assault. Similarly, in a 2019 case from the District of Columbia, a court found that a university displayed a callous and indifferent response to a report of sexual assault when it refused to move the alleged assailant out of the reporting individual's residence hall, and then charged her a fee for transferring dorms after initially telling her she would not be charged for the move. In another notable case, Doe v. Devonshire, a 2016 federal case from Massachusetts, the court held that there was no protected property interest in living in the residence hall. Thus, a university could remove a student accused of lewd behavior from his residence hall, even if that would require him to have a 2-hour commute to campus and lose access to support services offered to students with disabilities on campus. You should be aware of a possible trend developing in this area of law. While I previously described a housing move as an administrative action, at least one major appeals court, the Eighth Circuit, which governs a broad swath of the Midwest, including Arkansas, Iowa, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota, has identified an involuntary housing move as a form of disciplinary action in a 2019 decision. That case, Mayer v. Iowa State, was brought by a reporting individual who claimed the university violated her Title IX rights when it required her to move prior to the outcome of a disciplinary proceeding. Applying relevant case law, the court correctly held that it was not a Title IX violation to require the reporting individual to move and allow the respondent to remain in place. But the court took the law one step further, speculating that the university was, quote, respecting the respondent's due process rights when it chose not to remove the respondent until after the hearing. To support this suggestion, the court cited to language from the U.S. Supreme Court's 1999 Davis decision that it would be entirely reasonable for a school to refrain from a form of disciplinary action that would expose it to constitutional or statutory claims. Without actually saying it, the Mayer Court has effectively identified a housing move as being a form of disciplinary action, when the general position of courts is that a housing move is an administrative and is not the same thing as a finding of responsibility that leads to sanction. The takeaway here is that your policies must clearly identify administrative actions, such as a housing relocation, as administrative and not a sanction.
Indeed, the Title IX final rules make clear that housing moves and any other type of supportive measure issued before the determination regarding responsibility are not sanctions. A school absolutely cannot issue a disciplinary sanction without first issuing a final determination according to the defined grievance process for sexual harassment allegations. So where a school moves a student, whether that student is a complainant or respondent, before the final determination, that is not a disciplinary sanction. As such, should courts follow the direction laid out in the final rules, the Mayer decision may stay an outlier.
Schools also change students' class schedules. The Federal District Court for the District of Columbia recently held that an institution has a Title IX obligation to provide reporting individuals with reasonable accommodations to complete and succeed in their coursework. At the same time, putting significant roadblocks in their way can amount to discrimination and retaliation for reporting under Title IX. An institution may modify a reporting individual's class schedule to reduce the potential for contact with the accused person. According to some courts, like the Southern District of Ohio in a 2016 case, an institution can modify a reporting individual's schedule and not change the accused person's schedule without violating the reporting individual's Title IX rights. But other courts disagree in limited circumstances. An institution may run into Title IX liability where its action or inaction effectively forces the reporting individual to leave campus. Thus, in Terrell v. Delaware State from 2010, a reporting individual's allegation that a university's director of residence life and judicial affairs told her that she should change her class schedule and transfer out of any classes that she had in common with the male student, rather than taking action to remove the respondent from her presence, was among the allegations sufficient to overcome a motion to dismiss her Title IX complaint. And if a reporting individual leaves campus under duress, the institution must provide reasonable accommodations to help that student complete their coursework elsewhere. So in the case of Doe v. Howard University, a court found a potential Title IX violation where a university took a year to tell a reporting individual who had left campus that her transfer credits taken at a different school would be accepted and she would be eligible to graduate. That long delay created a significant roadblock to the reporting individual's ability to complete her degree. In making academic accommodations, the institution won't face Title IX liability simply because it declines to adopt the reporting individual's preferred remedy. Thus, in Kelly v. Yale University from 2003, a university's decision not to impose the reporting individual's requested academic accommodation that both she and the respondent be prohibited from attending classes and be provided with notes did not violate Title IX. Note that this case is something of an outlier. Like the court in Mayer v. Iowa State University, which was the housing case from the Eighth Circuit previously mentioned, the Kelly court reasoned that the university could have decided that this accommodation would expose it to liability because it would penalize the respondent before any formal determination of wrongdoing. Like the Mayer case, this decision assumes, without comment, that an academic accommodation that limits a respondent's access to class attendance is a kind of penalty and not an administrative move. This description is not accurate. It may have been overbroad and unreasonable to require both parties to stay away from classes, but such a decision would not be a penalty. It would be an interim measure pending a final determination on responsibility. Again, the takeaway is that your policies must clearly identify administrative actions, such as an academic modification, as administrative and not a sanction.
And as stated before, the Title IX final rules make clear that academic changes made before a final determination is issued are not disciplinary sanctions, but are a form of supportive measure. Disciplinary sanctions cannot be issued before a final determination.
Scheduled changes, leaves of absence, and remote attendance may also be necessary accommodations under the Americans with Disabilities Act, or ADA, Section 504 of the Rehabilitation Act of 1973, and state-level disability and human rights law. We cover disability law in detail in another module. As previously discussed, the student requesting the accommodation has the obligation to make the request, and it's the institution's job to provide the accommodations if they can reasonably do so. In one case, Schenck v. Carleton College, a reporting individual brought a combined Title IX and ADA claim against her college, claiming that she suffered post-traumatic stress disorder after her alleged assault. A federal court in Minnesota allowed her to go forward on her claims that the college violated her Title IX and ADA rights by failing to remove notations from her academic record that she had dropped several classes, not allowing her to take her classes remotely, or not allowing her to take only those classes held in sections of the campus where the accused was unlikely to appear. Ultimately, the court granted a motion for summary judgment to the college, as the evidence showed that the college actually granted those requested accommodations. But the case reminds us of the college's duty to provide accommodations under the ADA once requested. But courts have cautioned that the institution's response only needs to be reasonable under the circumstances. According to a New Jersey federal court in Doe v. Princeton University, a university did not act with deliberate indifference to a reporting individual's reported psychiatric issues following an alleged assault, where it allowed the reporting individual to take a leave of absence. This offer was not an act of retaliation for reporting the assault, and the university was not required to offer alternatives to the leave, such as a referral to psychiatric treatment or a postponement of a midterm exam. Similarly, a federal court in Pennsylvania held in the 2019 case of Roe v. Penn State that a university did not deny a reporting individual access to education or opportunities where an alleged assault caused her nightmares, trouble trusting others, and anxiety when alone. The institution's liability under Title IX rests on the nature of its response and not on the psychological harms caused by the assault. The court also decided that the university did not violate the reporting individual's Title IX rights, even if its Title IX investigators' questions exacerbated her mental health condition. In summary, institutions are obliged to provide interim accommodations to all parties to a disciplinary proceeding that arises from sexual and interpersonal violence. These measures have to be offered on an equal basis to all parties to the proceeding. If necessary, accommodations may be offered to one party, but not the other, as long as the decision is made without respect to the party's gender. And remember, an administrative measure is not a sanction.